Yes, so my Lord Sumption wanted me to expand on part of, and I've had to think about it over the short adjournment. So these are my submissions on this point. Now, it should be clear from the university's documents, let me just use that term broadly, and the college's documents, that the college is part of the university, either through use of the word of or wording to that effect. And then one has a legal relationship between the two which confirms the college's status. Now, if it is not clear, if the status of the college is not clear, that begs a question: why is it not clear? Why have the university and college not recognised the college as being of the university? It should be a relatively straightforward thing to do. And if it has not been done, we would say that is the end of the matter. Now, if the university has been set up by a charter or other document which precludes it from having a new college or any college, then that again is the end of the matter, because no college can be of that university. Or if the college cannot meet the governance requirements to which the university is subject, and for that reason cannot be a college of that university, that is also the end of the matter. Finally, if the university has an unfettered discretion as to which organisations it takes on as colleges, one would still expect to see a binding arrangement of permanence and exclusivity on the part of the college, whereby each party reciprocally recognises that the college has become a part of the university, and if applicable, both ensure their constitutions reflect that arrangement. The reason why exclusivity is important is on the part of the college is because otherwise a college could be of two universities, and I say that does violence to the idea of being of something. The college cannot be of two things. For example, if a college can admit students to two universities, it cannot be of both.
Even if those are for different courses?
Yeah, well, yes, lady, because then it would, in theory, be of two universities. And I say that's not possible. Being of something implies being part of the whole, not being part of that whole, and also being part of the whole of something else.
And does that actually follow? I mean, can an entity not be sufficiently closely affiliated to more than one institution?
It can be.
Part of it?
It can be sufficiently closely affiliated, my lord, but I say it cannot be
Has
of.
to be part of it?
Yes, I say it cannot be of more than one university. Just like a branch of a bank is of a particular bank.
So it may have a school of engineering which undertakes courses offered by the University of Cambridge, but it may have a school of modern languages which offers degree courses provided by the University of London.
Yes.
They couldn't be part of either.
No, it can't be part of two. Right. It has to be a college of a university. So I say it cannot be of. The word of implies being part of a whole.
It implies exclusivity, you say,
Yes.
as an institution rather than a course.
Yes.
And I suppose that could be solved by just creating two wholly owned subsidiaries and having one run one course and one run the other.
They're different colleges.
Yeah, with slightly different names of colleges, yes.
Potentially, but
I'm just trying to think how the implications of exclusivity.
So it's all or nothing with regards research too, is it? So if you do research, you can't be offering university courses and form a college which is...
So, lady, the exemption only applies to provision of education.
That's
so
right.
you can, it's perfectly possible that a university, and it happens, provides research and carries out research and also provides education. So the reference, that's an interesting point, because a reference back to the aim in the principal VAT directive is not necessarily to the sole aim, because we know, as my learned friend indicated, in EC Commission in Germany, that in that case, the German universities were assumed to be public bodies, and their research activities did not fall within the exemption, but their provision of education did. So there you have a public body which has both the provision of education and research as its aims. So that there you have more than one aims, I think. So as far as the education part is concerned, that's still covered.
Thank you.
I was now planning to go to what you said.
Can I push you a little bit more? When you read the European cases, they obviously explain the rationale of the exemption as being to avoid charging students VAT for their education, effectively. And I was wondering if that is the rationale, why do you say it isn't enough that a body admits students who become members of Middlesex University and provides them with courses which qualify them to receive a degree as graduates of Middlesex University?
Well, my lord, it's because one doesn't only look at the substance of the transactions when examining the scope of the exemption, because the scope of the exemption is defined not only by reference to the transactions, but also by reference to the criteria that suppliers have to satisfy. I do have some more submissions to make on this, but...
Don't let me take you out of your order.
Okay. So, my lady, may I now deal with the objection you raised in FBT to part of? Sorry, not in FBT, in Leicester University. That's MS 1783.
Flag?
MS 1783.
It's tab 11.
And paragraph 55. My lady says, Note 1B uses the expression the university and of the university. In the latter expression, this is of the university, the word of cannot mean belong to or form part of, since the former is not the case with regard to Oxbridge colleges, which are presumably intended to be covered, and the latter is included within the expression the university. So the objection to the part of construction is that part of a university will be covered by the word university in any event, and therefore the word of cannot be a reference to part of a university. My answer to that objection, my lady, is that since 1972, Parliament has not regarded it as beyond doubt that a part of a university will be treated as the university, and so has had to spell out that university covers a part of the university. One can see that in the Finance Act 1972. So my learned friend took you to this. It's 1699. And at 1699, we can see that the Finance Act 72, Group 6 Education, exempts the following. Item number 1, the provision of education if A, it is provided by university. And then if we turn over, there's a definition of university, note 3. University includes a university college. That phrase had disappeared by the time of the 1983 VAT Act, as we'll see. And the college, school or hall of a university. And I say what that is doing is spelling out that university covers a constituent part so as to ensure that constituent parts also benefit from the exemption. And we can see the same thing in the 1983 VAT Act, which is at 1703, just a couple of pages further on, 1703. And item number 1, 1703, exempts the provision of education by a university. And then we look at note 3. University means a United Kingdom university and includes any college, institution, school or hall of such a university. The terms of the exemption do not materially change, contrary to my learned friend's submission, in the VAT Act 1994. So, and one only needs to look at the structure of the exemption to see that. So what the 72 and 83 Acts exempt is the provision of education by a university, and they then put beyond doubt that university includes its constituent parts. What the 94 Act does is exempt the provision of education by an eligible body, which under Note 1B is a university and its constituent parts.
Of such a university.
I'm sorry, my lord?
Of such a university
Yes.
it can't mean is an integral part of the university, because they are separate institutions. It must mean having a relevant association with the university.
Well, my lord, I say it means part of the overall structure of the university.
Well, that, I think, is the same thing. You're not suggesting it has got to be an integral part of the same institution. You're suggesting that it has got to be associated with the university, surely, in some respect that is relevant. Which takes one back to the question, well, what are the respects which are relevant?
I say it has to be more than associated with, my lord. I mean, if we say associated with, that weakens the nexus.
It wasn't intended to do,
Yes.
because the nature of the association required can be more or less tightly formulated. But it can't mean is an integral part of the university.
Because that would
Unless, for instance, it's really intended that King's College, University College London, for instance, are not to be treated as being part of the University of
yes,
London.
my lord, I agree. My preferred formulation is part of the overall structure of the university.
Right.
Now,
So some kind of federation is envisaged.
yes. Now, the reason it was necessary for the legislation to put beyond doubt that the exemption applies to parts of universities was because, as Lord Justice Patten said in this case in the Court of Appeal at paragraph 19, MS 164, such parts could be said to be supplying education in their own right. So that could be said of an Oxbridge College, where teaching is provided by the college through tutorials. And the legislation doesn't, there's a suggestion in my learned friend's written case that the legislation discriminates in favour of the ancient universities. But I say what the legislation actually does is ensure that the constituent parts of the ancient universities are on an equal footing with other universities, so they don't lose out on the benefit of the exemption because of the way that they are organised. Now, if you were to interpret of to mean part of, that would not only be consistent with the ordinary and natural meaning of the word, and with the legislative history of the exemption in domestic law, but would also be consistent with the principle that exemptions from VAT must be interpreted strictly. We cannot lose sight of that. I say my learned friend has not presented any realistic alternative construction of the word of. She wants the term to be interpreted very broadly so that it encompasses potentially all kinds of relationships between universities and colleges. And indeed, she says in her written case at paragraph 66, MS 94, that her approach would not obviously exclude any particular type of relationship between a university and a college. And I say that would involve rewriting the statute to replace the word of with words like in connection with. And as I've already indicated, a college could have a connection with multiple universities. And on my learned friend's analysis, it could potentially be a college of all of them. And I say that is the loosest conceivable construction of the exemption, and so it seriously undermines the principle of strict construction, as well as being contrary to the ordinary meaning of the statutory phrase and its history. Now that brings me on to some of the EU law arguments and my learned friend's submission that to treat of to mean part of breaches the principle of fiscal neutrality. Now, my learned friend ran a similar argument in the FBT case, which my learned friend agree with. And it's worthwhile just going to that case at MS 1786. And you can see on 1786 the facts. The University of Wales had accredited the taxpayer a profit-making enterprise as a provider of education to a sufficient standard to prepare and examine candidates for the university degrees. A claim for exemption was made. The first-tier tribunal rejected the claim, found the taxpayer provided a university education, but that to fall within Note 1B, the taxpayer had to show, in essence, that it was an integrated part of the university, which it could not do. I say that's quite an interesting phrase by the first-tier tribunal there, because that illustrates what we say in our written case, which is that the part of test is really the apotheosis of the integration test, that the entities have to be so integrated that the college is part of the university. Now, there's a summary of my learned friend's arguments just over the page, 1787, and about 5 or 6 lines down, the principal issue before the Court of Appeal was whether EU law meant that a provider of university courses was entitled to the education exemption from VAT in the same way as a university, even if not so entitled under UK law. And there was a submission that UK VAT law did not comply with the principle of fiscal neutrality. If we skip the next 3 or 4 lines, they're not really relevant. The second ground concerned the taxpayer status as a profit-making enterprise. The Court of Justice made it clear that they weren't excluded. The third ground was that the taxpayer participated in the public purpose, which the Court of Justice held was a purpose of Article 132 to receive the benefit of the education exemption, namely to facilitate access by students to any form of education by reducing the costs and so on. Now, I'm not going to read out HMRC's arguments. They're in paragraphs 44 to 52. But they are similar to the arguments that HMRC make in this case. So HMRC's points were, in summary, were that the scope of the exemptions, as I have just said, is defined not only by reference to the substance of the transactions, but also by reference to the criteria that suppliers have to satisfy. And the supplier condition was that suppliers had objects similar to those pursued by bodies governed by public law, i.e. the provision of services of a public interest nature, and it was for the national law of each member state to lay down the rules in accordance with which suppliers would be recognised as having similar objects. And the member states had a discretion in that respect, and one only needs to look at Zimmerman, paragraph 26, for your note MS 1853, to see that. What HMRC said in FPT, which we do slightly differ from, which we do differ from now, is that...
Sorry, which paragraph did you refer to?
Oh, sorry, my lord, it's paragraph 26 of Zimmerman, MS 1853. Now, so HMRC said in FBT that the UK was entitled to require, as a matter of substance, that the supplier had to be linked with or form part of a university, because that was HMRC's then interpretation of Note 1B. In the present appeal, we say that what the UK has done in the legislation is require the supplier to be part of, not linked with, merely linked with. Now, if I could just take you to some parts of Milady's judgment, so paragraph 21.
MS...
Sorry, my lord, MS 1793. So, paragraph 21, Milady says that the jurisprudence of the Court of Justice supports HMRC's argument. Even though it is supplying educational services, FBT fails to meet the EU law compliant supplier condition for the education exemption. FBT has fundamentally misunderstood the statutory scheme, which in brief is that in the case of university education, the UK has exercised a member state option to, this says to recognise, I think this may mean to limit recognition of non-public law bodies carrying on qualifying educational activities to a small group consisting of colleges and halls of universities which are integrated into the university's activities. Now, Milady put it slightly different at paragraph 55. It's worthwhile just looking at paragraph 54 before we look at paragraph 55. So MS 1799.
Yeah.
And Lady points out at 54 that no one has suggested that Parliament had to use any particular form of words to set these conditions. These are the conditions referring back to MDDP, recognition of similar objects which organisations have them. It was therefore open to Parliament to exercise the UK's option by deciding which non-public bodies were to qualify, and then including a list of them in the relevant legislation. That's what Parliament's done in Note 1B. And then if you read paragraph 55, you'll see that at the end the language is slightly different at the end because it refers to colleges, halls and schools which are integrated into universities rather than the university's activities. And then
This sentence is making the point that I put to Ms Hall this morning, that it's drawn the line in the case of universities to those colleges, halls and schools which are integrated into universities and which are therefore imbued with its objects.
yes.
So that's to say the same objects which Parliament has judged to be similar to those of public bodies.
Yes. I'll explain how that works in the context of the domestic exemption in a moment. But you'll see that paragraph 56, for FBT to show that its exclusion from this group is a breach of the fiscal neutrality principle, would require it to say that it belongs to the same class as those institutions which meet the integration test in Note 1B. And it's worthwhile just reading paragraph 59 to yourselves. And the phrase Milady used at paragraph 56 of integrated into is close to, if not synonymous with, part of. But whether the term uses integrated into or part of, the point is that the UK is entitled to recognise the narrow class of bodies that fall within Note 1B. And the fact that an organisation does not fall within that class does not give rise to any issue in respect to fiscal neutrality. Now, how did we get to the particular terms of the exemption in domestic law? What's the relationship between the domestic exemption and the principal VAT directive? Well, I think a telling phrase is Milady's phrase, draw the line, in paragraph 55 of FBT. What we do know is that the UK is not permitted to exempt all educational supplies, regardless of who the supplier is. That is what the Polish legislation did in MDDP. And what the Court of Justice held was that that legislation was incompatible with the wording of the exemption in the Principal VAT Directive.
It can only exempt those universities, those institutions which share the purposes of public law universities. But it is open, presumably, to a member state to decide that all providers of university education in its own jurisdiction do share that purpose.
No, my Lord, I would say it's not open to the...
There've always got to be at least some that fail.
Well, my Lord, the reason I say that it's not open is for the reason that Advocate General Cockott gave in MDDP at paragraph 20 of her opinion, 1885, MS 1885 for your reference, was that the requirement of a similar object in the PVD would be rendered meaningless if the member states were allowed to exempt the educational services of every person. So she's saying, well, you can't do that. That's not permissible.
The objection, surely, is to a domestic law rule which exempts all providers of educational services in terms which would apply even to those providers which did not share the purposes of a public university.
Yes.
So essentially it's a complaint about the way in which the exemption has been formulated in Polish law. Now, it's perfectly possible to have a test which satisfies the EU requirements but will result in every Polish provider of tertiary education being exempt.
No, my lord, I say it's not, because that would mean that the term similar object in the Principal VAT Directive is meaningless. What the UK...
Let us suppose they said you have to have a similar object. That it could be that every single university in Poland does have a similar object, in which case they'd all pass. There's no requirement that domestic law must be framed in a way that ensures that some providers of tertiary education will fail the test.
Every single university, my lord, that's one point, but every single person providing education, I say, does render...
If that's how you define it, you're obviously right. But you can have a test which restricts it to those that share the purposes of public sector universities, and yet, on the facts, happen to cover every tertiary education provider. There can't be a rule saying that in every member state there's got to be a certain number of people who fail.
That is correct, my lord, because...
Right. So that's the only point I'm making.
Yes, my lord. And just on that point, what we do know is that the point that comes out of MDDP is that the member state has to draw the line somewhere. It can't do what it did in Poland, which is say, well, everyone qualifies as long as they provide education. It's also, just for your note, on discretion, worthwhile looking again at Zimmerman, paragraph 26, MS 1853, and also the court's judgment in MDDP, paragraph 37, MS 1899. Now, why do member states have discretion? Well, there's a hint of an answer from Advocate General Cockott in MDDP at paragraph 19 of her opinion, that's MS 1885, where she suggests that the reason that member states have discretion to lay down rules for the recognition of similar objects is probably because member states have very different educational systems. That's important because what follows from that is that there are no objective similar objects kind of out there at EU level. It's for the member state to draw the line as to what organisations are to be recognised as imbued with similar objects. And this may be relevant, it may not be, but there's one feature of MDDP which I think I should draw to your attention, which is that once the member state has drawn that line, an organisation cannot claim direct effect of the PVD on the basis that it ought to have been recognised by the member state as imbued with similar objects. As was made clear in MDDP, the Principal VAT Directive is only of direct effect if it is alleged that the member state has exceeded its discretion by including bodies it should not have in the way we saw in MDDP. See paragraphs 50 to 55 of the court's judgment at MS 1901. It's not of direct effect if it is alleged that the member state has not gone far enough. I'm drawing attention, there's no allegation, there's no suggestion here that direct effect is an issue, but it may help with the construction of the relevant provisions. Now, what's happened in domestic law? Well, the UK has drawn the line in Note 1B. There are no bodies governed by public law having the provision of university education as their aim in the UK. So in considering which bodies have similar objects, the UK would only have a hypothetical comparator. And that hypothetical comparator would be a hypothetical body, such as a hypothetical university governed by public law, having the provision of university education as its aim.
Why? Why can't it say this concept of a public law body providing tertiary education has obviously been extracted from various European countries in which the public law bodies do indeed do that, and I can look at them and see what their aims are and see what in this country are bodies with comparable aims.
Well, my lord, in MDDP, the suggestion in the judgment and in the Advocate General's opinion is that one is comparing the bodies that are exempt with public bodies in Poland. That was a suggestion. It seemed to be focused on the particular member state And it's whether...
Well, it may be that in Poland they did have public bodies with which to make a relevant comparison.
Well, my lord, it's because public law can operate in different ways as well across
Yes.
the member states. So,
Yes.
so the idea is that in the UK, a body is a body governed by public law if it's part of the public administration of the UK. So we say it's perhaps not a relevant comparator for the UK to look at whether, say, a public body is part of the public law administration in Poland. So when the UK is setting its own, kind of, deciding which organisations are imbued with similar objects, it should, in theory at least, be looking at, well, which public bodies in the UK have the provision of university education as their aim. But it doesn't matter too much. It doesn't really matter too much whether one looks at a hypothetical public law body in the UK or an actual body elsewhere. The point is, the UK has to then ask itself a question. Which organisations have similar objects to either this hypothetical university governed by public law in the UK or this actual university governed by public law somewhere in the EU? And the answer is, well, actual universities in the UK. They clearly do, for some of the reasons indicated by my Lord Reid, and parts of those universities. And then the line is drawn, and I say that's exactly where the UK has drawn the line. It's treated the supplier condition as being met if a body is a university or a part of a university.
But would you accept that in drawing the line, Parliament has also to comply with the overarching EU law principles of proportionality, certainty and fiscal neutrality?
Well, lady, I say not if the differential treatment is built into the system. And my learned friend herself recognises that if differential treatment is built into the system, no issue of fiscal neutrality arises. And just to illustrate that, if I could ask you to have a look at MS 79 in the core volume. So MS 79, paragraph 17 of my learned friend's written case, strictly the appellant's written case, I should say. And you'll see that in the final 3 sentences of paragraph 17, it states the member states' discretion to identify their own eligible bodies inevitably creates differential treatment. Because that differential treatment is built into the system, envisaged by Article 132 1I, such treatment does not breach the principle of fiscal neutrality. So here we have the differential treatment built into the system. So I say no issue of fiscal neutrality arises. But let's say I'm wrong about that. Let's say that there is still an issue of fiscal neutrality, even though the UK has done what it's...
Well, isn't that what Zimmerman says?
So what Zimmerman says, my lady, is the UK has the discretion to choose, essentially, which bodies are to be treated as being imbued with similar objects. That's also said in MDDP.
But having chosen, that exemption is subject to the rules on fiscal neutrality.
I haven't taken Zimmerman to say that, my lady, but it may.
Right,
But if it did, I do have a further submission. So let's say in this case somehow the issue of fiscal neutrality arises, notwithstanding that the UK has exercised its discretion as it's entitled to do and drawn the line where it has. What I say is that the principle of fiscal neutrality is not breached. The reason my learned friend gives in her written case for suggesting that it is that she says that a profit-making college will never be able to show that it is part of a university.
No, I think she's saying a privately funded, a private institution will never be able to say it's part of a university.
Yes, so that's paragraph 38.
But that assumes that one is talking about a body which is effectively a department or the same entity as the university. And that is part of the question before us.
But I say there's no reason in principle, at least, why a university could not recognise a private college as one of its colleges, with the private college continuing to enjoy autonomy and independence as Oxbridge colleges do?
Well, that's what Oxford and Cambridge both do in relation to private halls.
Yes.
They are
So-
private bodies.
Yes, there's no reason in principle why private colleges are excluded. If they can enter into an arrangement with a university where they become part of the university. And similarly, of course, there are also private universities, Buckingham, I think BPP. So the private college can become part of a private university as well.
I mean, you use this expression "part of" in preference, perhaps because it's a little looser, to constituent part, which was the expression used in the Court of Appeal. If one's asking whether something is a college or a hall of a university, is it perhaps legitimate to say that the United Kingdom's legislation has treated all universities, all things which qualify as universities, as automatically to be regarded as having the same purpose as the public sector universities on the continent? When it turns to halls, schools, colleges, etc., there has got to be some, I mean, your point is that you can't recognise absolutely all providers of tertiary education. That concern is satisfied, isn't it, if the hall or college or whatever has to share the educational purposes, the specific educational purposes of the university in question. And if the hall or college or whatever is allowed to admit students to the university who then become eligible to become graduates of the university, then it must be the assumption of Parliament, of the draftsman, that in the relevant respect it will share the objectives. The objective of the university is to teach people to degree or diploma level, and it is treating another body as eligible to admit students for that very purpose.
Well, I don't agree with that. That involves reading words into the legislation. I say what the statute
It
is doing.
involves
very
inquiring what is the relationship that is required.
Yes, but Lord, it's not just simply being able to admit students into a university, because a college could admit some of its students into one university, some of its students into another university. Now, where does that leave the word "of" in the statute?
Well, that assumes that you are right in saying that you have got to be part of the same institution.
Yes.
And that's the very question we've got to decide. So there is actually an element of circularity in this particular argument, isn't there?
Yes. So, my Lord, if you're against me on that, and then we fall back onto the broader SFM approach, I will come to my submissions on that. Why I say SEL still doesn't qualify.
Well, I don't think one needs to go quite as far as aspects, at any rate, of Mr. Justice Burton's decision. One can simply say that you've got to be sufficiently close to a university for your students to be their students.
So, well, that's another way of formulating the integration test, essentially.
Well, I wonder if it is.
Yes.
I mean, the way in which my lady put this in the FBT case was focusing on the need for the need for the exempt body under domestic law to be analogous to have analogous objects to those of a public law body. That's nothing to do with education.
But, my Lord, that's for Parliament to decide. Parliament's decided that.
Oh, yes.
So, yes, so we don't then look at whether something else has that object.
And if you've identified universities, if you've looked, for example, at the University of Padua, and you've decided that University of St Andrews is a comparable kind of a beast, albeit one is constituted under the public law of Italy and the other is not a public law body in this country, then it would follow that the colleges of St Andrews University, the schools of St Andrews University, and so forth are, as my lady put it, imbued with those objects.
Not necessarily,
Well,
because you have to...
Well, the constituent parts, if you like, of a university would be imbued, the parts would be imbued with the same objective as the whole.
They would be, yes.
It doesn't follow that any entity which could matriculate students to St Andrews University and educate them so that they were qualified to receive degrees from St Andrews University would ipso facto be imbued with the same quasi-public law character.
Yes, but Lord, this may, in terms of looking at who else may qualify apart from universities, I think it may be relevant to just go back to the language of the directive, because I think my learned friend used the phrase university level education, and the directive itself doesn't refer to university level education. It refers to the provision of university education. That's the activity, and then of course the supplier condition has to be met. The university level education can be provided in many ways. So for example, if a group of silks in my chambers got together to offer a distance learning course in their specialist area of practice, one could say that's university level. Dare I say it may even be above university level. But
It wouldn't meet the English law test for a university.
It wouldn't, no.
Distinguished as your colleagues doubtless are.
But, Lord, the important thing is that because the exemption relates to the provision of university education, that does entail everything that university education involves. So, for example, teaching by the university of the university's courses, participation of students in the life of the university, a meeting of the relevant regulatory threshold to be a university, and the assurance of a university standard. Now, there's no doubt that universities and their constituent parts meet those tests. They're universities. But then there is doubt, or it's less clear, in the case of other bodies. The UK has to draw a line somewhere, it's drawn it. I say that's the end of it.
What do you say are the purposes of a university governed by public law?
Purpose.
Are there any purposes of such a university other than the provision of university education?
Well, this
purposes?
is quite tricky because it's assumed that there is, because one looks at one doesn't just, when identifying similar objects, look to the activity, but to the body, but it's not spelt out what the public interest nature of the body is. I mean, it's assumed that it's generally acting with the view towards the public interest rather than with a view towards something else. But other than that, it's not possible.
That education is, by its nature, a public interest advantage. But if one's looking at if one's looking at the purposes of a university governed by public law, and then asking yourself, well, what other institutions have the same purpose? One has to start by asking oneself, well, what are the relevant objects of a university governed by public law? Now, I would suggest that the relevant objects are the provision of university education. But it's hard to think of another relevant object. They may have the object, for example, of conserving their capital and estates and their buildings and so on, but the object about which the directive is concerned is the provision of education.
But there must be some public interest nature in the body, because otherwise the directive wouldn't refer back to the objects being similar of the body, but simply say a similar aim to also providing university education. There must be something there. It's difficult to identify because public bodies across the member states are so varied, and we don't have a relevant public body in the UK. So it's difficult to identify exactly what it is, but it's...
And we've got to do so if we are required to look at the question, or if the member state is required to look at the question, what institutions in our country share the objects of public law universities elsewhere. The first question you've got to ask yourself is, well, what are their objects?
But my Lord, you don't have to ask yourselves a question. That's the whole point.
No, but the state does. And if we're going to understand what this directive means, we do.
It's no answer, Mr. Singh, as far as I can see, to say, well, the state's done that job for you, because the very reason we're here is that on the edge of this job, namely, if you like, the last 20% of the definition, we're trying to work out what the state has actually done. We're trying to construe a rather economically worded provision.
Well, so we have some hint in terms of, well, what does a university education involve? So for example, potentially there's a meeting of a relevant regulatory threshold by the university. That's one thing. There's an assurance of I suppose this is also compatible with a non-public body, but there is an assurance of a university standard, the students being involved in university life, all these things that are generally of public good. Students being absorbed into the university and kind of being imbued with the atmosphere of the university, all that kind of intangible.
I wonder if there's a different angle to it. Talking about the provision of education may be at too high a level of generality. If you think about universities in this country and public universities on the continent. Universities, first of all, are publicly funded. Some of them here have large endowments, but they all receive enormous amounts of public funding. Their educational activities are, to some extent, regulated, influenced, you can choose your verb, by public bodies, including, not least, the Department of Education, which will decide whether they want to encourage vocational or non-vocational courses, how many doctors do we need to train, so on and so forth. And so priorities for education, the types of subjects that ought to be taught, how much people should be charged in order to receive the tuition. And so all these areas of what they do are very heavily regulated in the public interest. So they have an objective which the state recognises and regulates of providing education in the interests, in the national interest, in a way which meets national requirements.
Yeah, my lord, you put it far better than I could. Essentially what the public university is doing is playing its part in a wider economy, and it's doing things which are judged to be overall in the public interest. Whereas an alternative provider, it could just decide to provide whatever university course generates the most fees, for example, which is not necessarily in the public interest.
One problem about this approach, surely, is that it would appear to be inconsistent with the ECJ's recognition that commercial entities may be qualifying education providers for this purpose. Now, if you take the University of Buckingham, for example, it doesn't receive any public funds. It is a university, but doesn't receive public funds. It's not subject to it. It could be subject to regulation, but in practice it is not, because the financial dependence isn't there. Now, I'm not sure that you could say that the object of the University of Buckingham is any different from the object of the University of Oxford, London, or Middlesex. The object in all of these cases is to provide university education. The terms on which they are able to do so may depend on how they're financially set up, how far they're dependent on the state, and all the rest of it. But the object is to educate people.
But, my lord, the terms on which they do so may then kind of be of broader benefit, as in it may lead.
But that would exclude institutions like the University of Buckingham, which do so on completely different terms.
Well, not necessarily, my lord, because the objects don't have to be identical to the public body. Similar objects, and a judgment has to be drawn. So they're similar. So one could say, well, in that case,
they're similar in only one respect: they educate people.
But in other ways as well, my lord, because that just assumes that the only thing that's going on in a private university is the provision of the university level education, but there are other things going on.
Could I just second? I'm sorry, I don't want to interrupt. The second that this is the debate we had in FBT, and it's recorded in the summary of Mr. Hill's argument, where he is attributed as saying the student will get the wider experience of university education if he attends a university. And that was seen as part of the distinguishing characteristics. When we ask the question, what is a university for? It's for more than simply conveying the education and the knowledge. It's for giving a much bigger experience.
Yes.
But that's, I think most people would say, that the wider experience of being educated at a university is part of the education itself. It's often been said you learn at least as much from your contemporaries as you do from your teachers. But that's education too.
Yes.
But it doesn't have to be, the institution could be very diverse, but it could still secure that same experience.
Yes.
And the question is whether it would do so.
Yes, and
on that.
yes, again, and that brings me back to the point I made earlier. The line has to be drawn somewhere, and I say, well, the UK could have potentially decided that there were other bodies which it was going to treat as being imbued with similar objects, but it made its choice in the way that it did. I mean, just going back to the public interest point, I think I'd just be repeating my similar objects point again, that they don't have to be identical. So do you mind if I turn my back this one? Yes, so I was now going to move away from fiscal neutrality unless there are any other questions on it. So now, my learned friend raised a point about legal certainty as well. And I would say that the part of test is legally certain. It's already been decided in FBT that Note 1B achieves legal certainty and enables an organisation to know whether it is entitled to the exemption. That's paragraph 56. And I say if Note 1B is interpreted more tightly than in FBT, which applied or which simply reflected the SFM approach, that makes Note 1B even more certain rather than less certain. My learned friend cannot realistically argue that the SFM approach is more certain. The SFM approach includes the part of test as factor one when asking whether there is a foundation document establishing the college as part of the university by way of a constitutional link. It then has 14 more factors plus anything else that's kind of generally considered relevant to the relationship between the college and the university, with no one factor being decisive. And such a broad and open-ended approach in my submission creates less rather than more legal certainty than the part of test. And it is worthwhile just drawing your attention to a couple of paragraphs of Advocate General Cocott's opinion in MDDP, page 1893, MS 1893. And it's paragraph 67. So the Advocate General says there can be no substitute. So she says, in my opinion, the exercise of member states' discretion in the recognition of private organisations cannot be left to either the national authorities or the national courts. Their consideration is necessarily related to the specific case and can be no substitute for an abstract rule on recognition. Such classification criteria have to be neutral, abstract and defined in advance. And then furthermore, the court has only recently indicated that the procedure followed by the tax authorities in assessing similar and competing bodies needs to be consistent. Such consistency cannot be achieved if each national authority or court takes a discretionary decision on individual cases, which will almost inevitably result in taxable persons being treated differently. And I say that is the very danger of the multifactorial SFM approach, and is why the part of approach should be preferred. And as I indicated earlier, we spent 6 days in the first tier tribunal arguing about whether SEL was a college of MU, and there really shouldn't be any need for that kind of exercise if there is to be a straightforward and clear application of the exemption. So I say this opinion supports the Court of Appeals test. There's just one final point on this issue that I wanted to draw to your attention. So it's MS 1799. It's Milady's judgment in FBT. And it's...
I'm so sorry, what page was that?
It's MS 1799.
Thank you.
And you'll see that at paragraph 57, Milady says that the requirement of legal certainty is achieved by the combination of Note 1B and the SFM factors. Now, of course, we would modify that and say, well, it's achieved just by Note 1B. No need to worry about the SFM factors. The reason I just draw this to your attention is that my learned friend suggests in her written case that in this paragraph, Milady was endorsing the SFM multi-factored approach as opposed to a more hard-edged approach. That's paragraphs 55 and 59 of the appellant's written case. And I would respectfully submit that Milady was not doing that. There was no issue or argument before the Court of Appeal in FBT about what the correct approach to the construction of the domestic legislation was. That was because the upper tribunal had found that FBT had no entitlement to the exemption in domestic law, and there was no challenge to that finding in the Court of Appeal. So this shouldn't be taken to be an endorsement. It just wasn't an issue. The point wasn't argued as it has been today. So for all of those reasons, I would ask you to endorse the part of approach favoured by the Court of Appeal. Now, if you decide that the multifactorial approach favoured by my learned friend is the correct approach, we say that the first-tier tribunal, in this case, nevertheless erred in law. And I was just now going to identify what I say the errors of law were. Now, I don't want to take you to too many documents and go through this in much detail because it's all set out in the written case and it's reflected in the various judgments. It's because it's all there for you. You have all the documents. I don't think you need. You're not going to get much help from me going through it again in a lot of detail. But just a few points I'd make on this. So the upper tribunal held that paragraph 126, MS 292, that the only realistic conclusion from the evidence was that MU and SEL had a relationship which fell short of constituting SEL a college of MU. And that was effectively a finding that the first tier's decision was irrational. And I say it was effectively a finding that the first tier's decision was irrational. And I say that was the correct finding. And again, without going through this in much detail, there is an agreed statement of facts before you at MS 59 to 68. That statement is based on the facts as set out by the Court of Appeal from paragraph 40, MS 173. The facts set out by the Court of Appeal were taken from the first tier's decision. You'll see that from paragraph 39 of the Court of Appeal's decision. The agreed statement of facts is therefore essentially a summary of the facts found by the first tier tribunal. And there is nothing in the agreed statement of facts combined with any other facts found by the first tier tribunal that comes remotely close to justifying a conclusion that SEL was a college of MU. The flavour you will get from the agreed statement is that the SAE Institute and MU were in a partnership arrangement, and indeed the high-level agreements between them were called partnership agreements. What happened between the two parties was that MU would validate some of SAE's courses so as to entitle students on those courses, including students in the UK, to either a diploma or a degree from MU. From September 2010, SAE could itself validate some of its courses, which led to awards of degrees by MU. Both SAE and MU benefited from this relationship. So MU, for example, received 7.5% of the revenue paid by students on SAE courses in the UK, leading to awards from MU, and the reference for that is MS 483. Additionally, as the Court of Appeal noted at paragraph 52, MS 178, MU, Middlesex University, which did not give evidence in support of SEL in SEL's appeal, told HMRC in November 2009, when asked whether SAE was a school or college of MU, that SAE was a partner institution and was in the kind of arrangement with MU that had the greatest distance between MU and its partner. And the reference for that meeting and the notes is MS 1473 to 1476. And there's an email from MU at MS 1480 where MU amends some parts of the notes of the meeting, but not the key parts. And bear in mind that this meeting was 6 months after SEL had become a college of MU, according to the First Tier Tribunal. And I say that MU's statements and the findings of fact by the First Tier Tribunal demonstrate that the relationship between SAE and MU was a mutually beneficial, cooperative, commercial relationship. But on no rational basis could it be said that SEL had at any stage become a college of MU. Now, putting aside the irrationality of the FTT's conclusion, one sees further errors of law. I'm not going to take too long about these, but just in 5 or 10 minutes I'll highlight them to you when examining the FTT's reasoning. So if I could ask you to go to the FTT's decision at MS 235.
Sorry, MS 235?
Yes, 235. And it's paragraph 190. You'll see that the FTT says we find there's some acknowledgement by MU of the status of SAE Institute, and the entity in the UK which carries that status is SEL. The extent of the acknowledgement is limited, in that SAE has been designated since 2010, or possibly earlier, as an associate college, and since September 2010 as an accredited institution. On the basis of the evidence, we find on the balance of probabilities that SAE Institute was regarded informally by MU as an associated college as early as 1st May 2009. Now, as the upper tribunal noted at paragraph 117, MS 289, the FTT's finding that the SAE Institute was regarded informally by MU as an associated college as early as 1st May 2009 was based on no evidence. And indeed, the FTT itself said, paragraph 167 MS 231, that there was no specific evidence to show an effective date for SAE's attainment of associated college status. The question was not in any event whether the SAE Institute was a college of MU, but whether SEL was a college of MU, as the upper tribunal also recognised at paragraph 117. Informal regard does not indicate that the SAE UK entity was a college of MU, as the upper tribunal also noted at paragraph 122, and informal regard merely as an associated college positively implies a relationship short of integration, as the upper tribunal indicated at paragraph 115. And then just finally on this decision, if I could ask you to go to paragraph 293, MS 253. Paragraph 293, the factors which we consider to carry the greatest weight, this is in arriving at the conclusion that SEL was a college of MU from the 1st of May 2009, are 1. status of associated college, I've already made submissions about that, combined from September 2010 with status of accredited institution. Now, the status as an accredited institution simply meant that the SAE Institute could itself validate some of its courses, which led to awards of degrees by MU. It does not go to the question of integration, and in any event, it's only relevant from September 2010, not the 1st of May 2009. Then the next point, too, long-term links between SAE Institute and MU. The long-term links were not between SEL and MU. Until the August 2011 Special Associate College Agreement, or SACA, there were no agreements at all which sought to establish a relationship between MU and specifically the SAE UK entity. And in any event, long-term links are consistent with a well-established partnership arrangement and do not suggest integration. The next point relied upon by the first-year tribunal, just the next part of 2, is similar purposes in terms of the standard of education. Well, that's irrelevant to the question of integration. And then the next 2 matters, courses leading to a degree from MU and conferment of degrees by MU, are matters that go to validation and cooperation rather than integration. So we therefore have a decision from the first-tier tribunal that is riddled with errors of law. The first tier's overall conclusion was irrational. It made its central finding based on no evidence. It did not ask itself the right questions, and it took into account matters irrelevant to integration when concluding that SEL was integrated with MU. So I say, accordingly, even on the integration test, SEL fails, and the upper tribunal was correct to so find. I think I have 23 minutes left, but I don't think I have anything more to say to you. So may I just turn my back and check? Thank you. So unless I can help you further, I will ask you.
Thank you very much, Mr. Singh. Yes, Ms. Hall.
There has been much discussion during the learned friend's submissions about the identification of the relevant objects of the university. And the answer to that, quite simply, is in the wording of Article 132 itself, which I would invite the court to review.
Page number again?
MS 1750.
175. Thank you. Yeah.
So Article 132 obliges member states shall member states to exempt the following transactions. The key words are the words "the provision," and it's the provision of certain types of education. And this is at the absolute heart of our case, because it is the provision of certain types of education which is identified as the aim which bodies governed by public law must have. And it's not just the provision of any education, it's the provision of certain types of education. And we are only concerned in this appeal with the provision of university education. We're not, as we know, concerned with bodies governed by public law, but we are concerned with organisations that have been recognised by Parliament as having similar objects to bodies governed by public law. The distinction between aims and objects is of no consequence. So the answer to this debate as to what the relevant objects are is defined in the provision itself. namely the provision of education. So Parliament must be presumed to have decided that all UK universities have the provision of university education as their aim. I say all, I should say UK universities typically have university education as their aim. With any rule, there are always going to be outliers. And the key point here, and this is central to the correct focus when it comes to the sufficiency of the nexus between a college and university, is that the other organisations, which includes a college of a university in this jurisdiction, must share similar objects. Namely, they too must have the object of providing university education. Now, that must mean university education in terms of the academic level of education, because Article 132 itself recognises that organisations other than universities can provide university education. So it can only be a reference to university level education, and the First Tier Tribunal was quite correct to have accepted our submission to that effect.
I mean, is there a qualitative condition to be satisfied if something is to constitute education? Let us suppose that you have an institution which exists entirely in order to provide training in some recreational activity. Would that constitute, as I understand the EU case law, the answer is that that would not constitute university education in the relevant sense?
That is correct, my lord. The European Court in the Horizon College case said as much.
Which case?
The Horizon College case. That is the case in which the European Court of Justice defines the concept of education, which is an autonomous concept of European law. The relevant passage is set out in our case at, I believe, paragraph 64 from memory.
64.
I believe so. Let me just check that, please. It's worth turning it up. If you just search Horizon College. 63. I'm obliged. So there you have the very broad definition, which inferentially excludes purely recreational instruction, as it were, or experience. It was my Lady Arden, in the Leicester case, who pointed out that the concept of education cannot encompass purely recreational activities. And with respect, her ladyship was right so to conclude. If I may just be given one moment to find the relevant passage. Yes, paragraph 56 at MS 1783, just above letter G. However, in the context of note 1B, the links must be of an academic nature rather than pastoral or recreational, or for the purposes, however valuable, of providing representation for one section of the university community and organs of the university. That, of course, was the position with regard to the Students' Union. That's a very long answer to your question. I respectfully agree that recreational activities are excluded from the concept. If I may now deal with Mr. Singh's submissions in the order in which they were made to the court, the fundamental difficulty with his submission that the ordinary and natural meaning of the word of is part of is that construction disrespects Article 9 of the Principal VAT Directive, which envisages that those who make supplies, of which a college is an example, must do so independently. Independence having been defined by the Nigel case, NIGL, which is in our printed case. That construction, therefore, goes against one of the core objectives of the VAT system, and under my leasing principles, must therefore be rejected.
Do we have the Nigel case in the bundle?
It's not in the bundle. What I have done is to simply recite the only relevant paragraph, but we are happy to provide a copy of that if it would assist.
Yes, thank you. Yes, please.
That's been noted, my lady. With regard to the submission that what is required is recognition in the university's constitutional documents, I have the following response by way of reply. The first is that such a criteria of recognition contradicts the well-established principle clearly articulated in the BLP case, that the test, whatever it is, must be objective. That is to say, it is not permissible through private law agreement or an assertion made in a document that you do, in your own view, belong or not belong to a particular fiscal classification. The relevant paragraph in our printed case is paragraph 74, which sets out the relevant part of the court's judgment in BLP. That is at page 96. The citation of BLP is in the context of the upper tribunal's decision, on which you've just heard submissions. I may as well deal with it now. The upper tribunal made a fundamental error in its approach to this question by hinging the test on what it called the common understanding of the college and the university, which imported an element of subjectivity, which was contrary to the principle established in BLP. And that principle essentially is set out at page 97, MS 97. The correct approach is to ask whether objectively the facts and circumstances surrounding the relationship justify the conclusion that a college is of a university. And what the court said in paragraph 24 of its judgment is that if it were otherwise, objectively identical situations would be treated differently depending upon the subjective assertions of the participating parties, which would breach the principle of fiscal neutrality and legal certainty and undermine a core principle of the value-added tax system. The second difficulty with the submission is that it breaches Article 131 of the Principal VAT Directive. If I could remind the court that that provision set out at NS 1750 obliges member states to apply the exemption in accordance with conditions which the member state shall lay down for the purposes of ensuring the correct and straightforward application of those exemptions and of preventing any possible evasion, avoidance or abuse. The proposed test, namely recognition in a university's constitutional document, firstly disregards those colleges who don't have a constitutional document. Secondly, it, far from avoiding evasion or abuse, it will encourage such evasion or abuse. It will encourage the drawing up of private law arrangements in order to ensure that the organisations in question meet the test. The further difficulty with the proposed test is that it contradicts recital 4 to the principle of that directive, which tells us, just to remind the court, that member states must, as far as possible, ensure that conditions of competition are not distorted at a national or community level. The proposed test would achieve precisely that result, since it would favour those who happen to have a constitution and those who happen to have met this test, and that cannot be the right approach.
It's unlikely to make a difference to the consumer of the course, whether or not there's any.
Yes, yes, my lady, because from the student's perspective, the constitutional or governance relationship do not have an impact on that student's ability to access education, to receive education. It is a matter of indifference to a typical student as to what the constitution or governance documents say about the relationship. What matters is that the university and the college are working together in providing the education of which the student is a beneficiary, which is why central to our test is the focus on the activity of providing education, since it is from that activity that the student benefits.
Well, but the argument is that once the member state has chosen the condition, you look only to domestic law, and there are no EU law principles such as the principle of fiscal neutrality. Is there some authority of the CJU which deals with that point? Does
Yes,
Zimmerman tell us?
there is. Yes, Zimmerman does. I was going to come to
Fine,
Zimmerman.
if you could just deal with that at some stage.
I should say, first of all, that I profoundly, and with the greatest respect, disagree with that submission. Zimmerman alone tells us that it is wrong. Zimmerman is part of a long line of cases concerning the health and social welfare exemption. Kingsland, Dornier, other cases have looked at this issue, and it is well established that even after domestic implementation has been effected, it is still subject to European law. You have this submission in our case, my lady, which, in the context of Mar leasing, reminds the court that, by reference to the Marks and Spencer case, that a member state's obligation to give effect to European law is not extinguished at the point of implementation. It continues. It can't be that easy to get around fundamental EU law principles.
Yes, but we were taken to paragraph 17 of your case, which says that because the differential treatment is built into the system envisaged by Article 1321 little I, such treatment does not breach the principle of fiscal neutrality.
If I may address that, my lady.
Yeah, at some point.
The mere fact, which it is, that Article 132 permits member states to apply differential treatment between other organisations does not give member states the licence to discriminate such that the principle of fiscal neutrality is breached.
The problem surely is that in Zimmerman they were concerned with the exemption for outpatient care, and that exemption, unless I've missed something, did not depend on any discretionary decision on the part of a member state. So that one can, I mean, the considerations which suggest that an element of discrimination may be built into this system simply didn't arise.
Well, with respect, my lord, it did, if I may explain why.
Of course.
I absolutely take my lord's point with regard to the concept of a charity. A charity is an independent, autonomous concept of European law, such that profit-making organisations can be characterised as a charity under European law. So yes, at that level of generality, only European law was engaged. But in Zimmermann, for example, the focus of the court's attention were rules of domestic law, and the rule of domestic law, which the European Court refused to sanction, was a rule which stated that unless 2/3 of a provider's receipts were from state sources in the previous calendar year, then such providers did not have the equivalent of eligible body status. And what the European Court found, that whilst other domestic recognition criteria were entirely compatible with the aims of the provision under consideration, that criterion of recognition was not, because it capriciously excluded those providers who happened to have started in year one and had no reference point which they could use to justify their claimed status as a charity. So both and Kingsland, it's not called Kingsland, it's called King's Crest, thank you. King's Crest similarly was concerned with our Parliament's own definition of what a charity is and what it is not under the Value Added Tax Act. And that
The objection in Zimmermann was to the exclusion, the automatic exclusion of commercial providers, which was the substantial effect of the 2/3 requirement, or have I misunderstood the position?
With respect to you have, my lord, if I could just explain that the European Court was quite content to endorse the 2/3 requirement, because the 2/3 requirement was reflective of the provider's status as a charity, in that its activities were manifestly linked to the activities of the state, such that 2/3 of its receipts came from the state. The offending provision was the provision which prevented the, in that case, the Zimmermanns claiming the relevant status because of the previous calendar year condition. And en route to that conclusion, my lord is quite right to observe that the court stated that it is not permissible to discriminate against commercial law providers.
Right.
So, and the point here, my lord, is that Zimmermann, King's Crest, Dornier, all of those welfare cases, they're all highly relevant. They're concerned with public interest exemptions, which necessarily engage Article 131, the obligation to apply in a straightforward manner to prevent evasion and avoidance, and 133. And critically, I just ask the court to note that the European Court in Horizon College was quite content to import the reasoning of the courts in Zimmermann and other such cases in the context of its consideration of the education exemption. And that of itself demonstrates the relevance of the reasoning in those cases to the task which this court must discharge. So I think I was on the third difficulty with my learned friend's test, which was recital 4. The approach of focusing on the recognition in a university's constitutional documents will distort conditions of competition. It will make it far too easy for providers to simply draw up, by private law arrangements, the requisite descriptions without having regard to how the education and in what manner the education is actually being provided. Perhaps, and this is my fourth criticism of the submission, I make it in the context of a paragraph in Zimmermann which might assist this court in identifying the correct test. The submission I make is that the test advanced by the respondents is not an appropriate mechanism for meeting the need to recognise organisations as having similar educational objects. And the appropriateness of any given criterion that's under consideration by reference to whether it is an appropriate mechanism might be one way to unlock the difficulty of articulating a clear test. And if I could just ask the court to note that approach in paragraph 37 of Zimmerman, it's at MS 1855. And if I could if you just bear with me for one moment. Yes, this is the point that I was making in response to my Lord Sumption's helpful intervention. At paragraph 37, page 1855, the court is there referring to the 2/3 threshold and says in the second sentence, the fact of requiring such a threshold is a similar mechanism for meeting the need to recognise that certain organisations are charitable, and therefore did not, as you see from the penultimate line, in principle go beyond the limits of that member state's discretion. And the question in this case is whether the constituent part of test, which is essentially the test being endorsed by HMRC, is a mechanism that meets the need to recognise certain educational organisations as colleges, institutions, halls of a university. And we say it is not, for the reasons I have given, incompatible with Article 9, it disrespects Recital 4, it disrespects Recital 7, it disrespects BLP.
I can well understand why you say that if the only question, the only legitimate discriminatory question which Article 131 permits is to see whether the non-public law organisation provides university education, the constituency test adopted by the Court of Appeal doesn't do that. But why does Mr. Justice Burton's test do it either? The integration test. I mean, if the only question is, has this other entity, is its object to provide university education? And that's a very short question, one might think, and didn't need 12 probanda of infinitely variable weight.
Well, my response to that is that one cannot reasonably...
No, it's 16, isn't it? Or is it 15? 15.
It's not just 15. It's
Plus any others
plus
that might
all
help.
Other facts and
Yes.
circumstances, and that's an important point.
Yes.
So the SFM test, if I may call it that, ultimately focuses on the manner in which education is provided. That is to say, it accepts that the objects of an organisation can be inferred from its activities. Identifying the objects of an organisation cannot stop with an evaluation of its formal constitutional governance and contractual documents.
I mean, the problem about Mr. Justice Burton's formulation of the test is it's much more complicated than it needs to be. You can gather up most of the criteria that he identifies under a single broad heading. And if you did, you would have got to the object of the exercise rather more easily than he did.
To be fair to, I entirely endorse that observation. I would submit that many of the factors, a number of the factors, as the First Tier Tribunal recognised, are not particularly helpful in this case, or indeed any other case. But as Mr. Justin Burton himself acknowledged, it's not a tick box exercise.
But I think my real question is why, if there are all lots of ways of working out a level of integration, what's integration got to do with it? Why does there have to be integration between the entity and a university in order to decide whether it's providing university education, if that's the only legitimate basis of distinction?
Because one has to give a meaning to the word of.
Well, I know, but is it a legitimate? Is any definition of legitimate by your definition of what this discrimination permits?
Well, yes, I would say, I repeat our version of the test, which is whether a college and a UK university are sufficiently integrated in relation to the provision of education by the college to students. That is a high-level articulation of the test, which I say works and which can be met by looking at all the facts and circumstances of any particular relationship, which are extremely wide and varied in the UK for reasons which I've already given. So the focus, this case is not just about the word of. This case is about what this court must presume was Parliament's intention in implementing 1B. Presumption must be that Parliament implemented 1B as a way of recognising colleges of a university as organisations with the object of providing higher education. Now, the integration test, which we advance, pays homage to the very purpose of the exemption. I could just remind you of the title to Chapter 2 in Title 9 of the directive, which is that it is for exemptions for certain activities in the public interest. Hence the need to focus on activities. Hence cases such as town and county factors and Gregg, which focus on the formal legal environment in which those activities take place. Hence the first-tier tribunal's indifference as to the fact that SETL sold its business to SEL because the underlying activity continued. And that is why in Gregg the European Court described the approach of the Greggs as being too narrow and formalistic, because it did not pay enough homage to the public interest objective of the article, which is focused very much on activities. So that without an integration test, without acknowledging the need for there to be integration in relation to the provision of education, fails to acknowledge that which must be presumed from Note 1B, which is that Parliament recognised colleges of the university for the very reason that their object is to provide higher education. That is why they have been recognised by Parliament. So this case is not just about the word of, and to so conclude would be to ignore the all-important European context in which Note 1B must be placed.
Now, you've been speaking in reply now for about half an hour. Are there further points you have to make?
I have indeed. If I could just take my, I haven't really got beyond the first page, but let me go as quickly as I can.
Well, if you could be quick, because you've been speaking for twice as long now as Mr. Singh.
Well, that is a fair observation, my lord. That is a fair observation. So if I may be given no more than 3 minutes. Paragraph 33 of the judgment of Lord Justice Peter Gibson at MS 1779 has, with respect, been misread by my learned friend. I just ask you to note that what the learned judge was referring to was that in those cases where there are separate entities, then such separate entities can be recognised. The need in HMRC's test for a legal relationship to be binding cannot be right. It is a well-established principle of VAT law that the binding nature of an agreement is an irrelevance. See town and county factors. See cases such as Fisher, where unlawful gambling was nevertheless found to be exempt because the gambling took place, and that was all that mattered. it was said that some sort of federation was envisaged by Note 1B. That cannot be right because the words used are any college of a university, and a university is not defined by its type. And finally, conscious of the time, I make this point, that we do not, contrary to the submission that was made by Mr. Singh, advance a test which has the loosest possible construction. We do the opposite, because we tether our test to the very public interest exemption, which was the basis upon which Note 1B was implemented by Parliament, by focusing on the provision of higher education as opposed to the formal framework within which that education is being provided. Those are my submissions in reply.
Yes. Yes, yes.
I've been told by my learned junior that I have to ask the court to defer questions of costs until the reserved judgment, if that is acceptable to
Yes, that's our usual practice.
Thank you.
Now, parties are going to provide us with a note on the legal definition of a university.
Yes,
Could we ask that that be done, say, within the next week?
certainly.
Thank you very much. Well, we're most grateful to all counsel and also to those sitting behind them who've contributed to the preparation of the cases. You presented us with an intriguing problem. We'll enjoy thinking about it, and you'll be informed of our decision in due course.